it's crazy that, people will get an opportunity of a lifetime and really just screw it all the way up. When you get the opportunity though to like be in position, that's when you got to think more. That's when you really got to put your thinking cap on and think different, because you got an opportunity that a lot of people will never get. And these dudes don't be thinking like that. They think that because they got the money that they can buy their way out of anything, because they running around jewelry, nice cars, home, that they unstoppable. But it only makes you a target. And when you think about this, right? The people that do this for a living, that enforce the law, they're not living like you're living. They get a hard off of taking you down when you're doing wrong. They're in law enforcement. And you act like the law doesn't pertain to you. So they're going to show you how they want to enforce it when you make the decisions to break it. These people are nowhere near living like you, but their job is to enforce the law. The people that's rich, they don't think about it like that. All the people that's enforcing the law, they don't live like you. So of course, they're going to want to make an example out of you. A lot of people that's in law enforcement, they want anybody that is rich, that feel like they can break the law, they really want them to suffer. Like, hold up. We got to abide by the law, but you think because you got money, you don't? So we're going to make sure that we enforce the law on you. And we not going to hold back. Durk played himself out of position. Yeah, he played himself out of position, man. Straight up. It says the clearest example of prosecutors' free hand, and one that we see unfold in real time, is with respect to the nature of the quid pro quo that allegedly motivated the murder. Not one government witness has ever said that Mr. Banks paid for or offered to pay for the charged murder with music videos or rap lyrics. Not one government witness has ever said that his motive to commit murder was to be featured in music videos or rap songs. And they use the case law to reference to. Reversing convictions where there were no evidence that cash paid by a solicitor to murder was the motive for the murder. That's the case law. Yet these prosecutors have decided on their own, and in the absence of corroboration, that any musical collaboration between Mr. Banks and any alleged co-conspirator, post dating August 19, 2022, was quid pro quo for murder. The timing of this development exaggerates its prejudicial effect. Either the prosecutors just invented this theory 2.5 weeks ago, or they have purposely hidden this theory from the defense until then. Either way, it is not fair and it cannot stand. If this court does not dismiss the indictment as vague, it should at least take firm measures to guard against the constant shifting of the government's quid pro quo theory. Do you see that though? This is how they do with the rules though. They make and break the rules as they go. Now this is an attorney, right? a defense attorney, because they're all attorneys, right? But this is a defense attorney addressing this, and they don't care. It's their game. So, of course, they're going to play the game the way they want to play the game. Durk ain't think about this. This is something Durk wasn't thinking about. That you playing with their game. And, of course, they're going to play it their way. You know, the attorney, he got a job to do, right? But he go home at the end of the day. So him going home at the end of the day, it is what it is. You got to be the one in the situation, hoping he can help you get out the situation. So it really doesn't affect him. So of course he's going to say certain things with the law, but when it's in a situation like this, right? This is the, you know, highest crime that you can be charged with. Man, they really don't be having no sympathy for you. It's a criminal situation that they ain't got no sympathy and they don't care at all. Durk thought his money was going to be able to get him out of everything. The court should order a bill of particulars and review the grand jury's transcripts in camera to ensure that the theory presented at trial is tied to what it was presented to the grand jury. At the very least, the court should constrain the government's theory to what is contained in the discovery it relied upon the response to the court's November 18th order. That filing contained no evidence that the music videos and rap lyrics upon which the government now relies were consideration for the murder. Now, y'all see that now, right? Everybody says that they can't use rap lyrics, right? Now, at first, the government hit them with the wham wham and act like they wasn't going to be using the lyrics. Now, they're using the lyrics. They hit them with the wham wham at first and act like they wasn't going to be using the lyrics. But now, they losing the lyrics. Straight up. They using the lyrics now. So if they using the lyrics now, and all Durk talked about was sliding and sliding for Vaughn, right? And they paint this picture to the jury about sliding for Vaughn and Durk having these videos, man, Durk's in trouble. Yeah, he's in serious trouble. Straight up. You know, he's in trouble. The filing contains no evidence that the music videos and rap lyrics upon which the government now relies were consideration for the murder. And for good reasons, no such evidence exists. In lieu of evidence, we have the very thing that higher courts have repeatedly cautioned against: prosecutors who fill in the gaps in order to win convictions. Man, listen. They gonna do what they want to do. You gotta appeal it, try to fight back, you know, but they gonna do what they want to do. So basically, the government's saying they're gonna do what they want to do. They're gonna use your rap lyrics against you. And you gotta try to fight it with your motions and the appeal. And they're gonna try to make some points that they might feel is valid why they're gonna use the lyrics. Now, if the lyrics is specifically saying that he was gonna slide for Vaughn, which we know Durk got songs out there talking about sliding for Vaughn, right? They gonna reference to that. They gonna reference to that. And it was goofy for Durk to do it. You know, it was goofy. So now you got music saying you gonna slide for Vaughn. You got your homies that's telling, right? And let's just be real, right? They're not allowing Durk personally to get the evidence of the people that's testifying, right? They're allowing his lawyer to review certain things, whereas though he can see it, but he can't keep it, right? And he can't tell Durk about certain things, right? So you got these people that are gonna testify, right? And they're gonna say certain things to the prosecutors, right? Now, the prosecutors is not gonna reveal everything to the attorney. When the people get on the stand to testify, you really don't know what they're gonna say. You don't know what they're gonna say on that stand. Just because they made statements don't mean that when they get on the stand that they're not gonna add some more things. So if you think that the statement that they made is the only thing that they're gonna say, you don't know what they're gonna get on the stand and say. They get on the stand and start saying some more stuff. Now Durk in a situation. Durk about to see that his homies that he thought was his homies ain't his homies. He about to see. Literally. The homies that, you know, he thought was his homies, he about to see. The danger of a vague indictment realized. A real danger created by this indictment, vagueness, is that at trial, the government could point to any instant of Mr. Banks' generosity with an alleged co-conspirator, or any time that an alleged co-conspirator received a benefit from his proximity to Mr. Banks' success, and the government will cite it as a bounty or a downstream benefit of the murder. If Mr. Banks picks up a dinner tab, if Mr. Banks buys somebody a gift, if Mr. Banks allows somebody to accompany him on a private flight, if somebody collaborates with him on a musical project, the government may decide that is the murder quid pro quo. You hear that? Now, his attorney is trying to fight back about that, right? The attorney is trying to fight back about that. But this is what the government going to do. This is what they going to do. Because it's their game. They're going to use that, anything that Durk did for his homies, that this was for them to do anything Durk said. Whenever Durk had a problem, being as though that he was providing a lifestyle for his homies, this why they went out and did it. The game. Durk ain't think about this. See, Durk thought that if he did it slick and not did certain things directly, he would be good. But he wasn't thinking that the government is going to look at, well, anything you did for your homies, that was an advance payment for whenever you needed them to slide for you. This is what niggas don't think now. If Durk would have been thinking this, he wouldn't have did what he did. But all Durk was thinking about was, all right, I don't want to be connected directly. Don't use my credit card. Don't do this. But it's their game, and they're thinking about how they want to do it. It's getting, it's about to get real for Durk. Straight up. This is problematic for several reasons. One reason is that a pecuniary benefit paid by a solicitor of a murder to the murderer does not satisfy the statute quid pro quo requirements in the absence of any overt agreement or understanding between the solicitor and the murderer that the pecuniary benefit is in exchange for the murder. Now, his lawyer can try to act like, Durk dealing with certain people, and not saying something direct, didn't get Durk to do this and do that. But the lawyer don't know what the co-defendant is going to get on the stand and say. Yeah, the prosecutors are not going to lay their whole case on the table. Straight up. The prosecutors are not going to lay their whole case on the table, man. No, they're not. Because it's a game. They're going to put just enough out there to try to cover, to make sure that they don't all the way violate the law. But then they come in with a surprise at trial. They going to have a surprise at the trial. Straight up. You better know that. It says, concluding that tracking the language of the statute will not render an indictment valid if it omits a statement of facts and circumstances that would inform the accused of the specific offenses with which they are charged. Yeah, you're supposed to know, but they want to keep you off balance to play the game. Instead of for some other purpose. Let me see. Here. Let me see. Absent any evidence that Mr. Banks' purpose in bestowing benefits on others is to induce a murder, then those benefits are irrelevant. Excuse me. Another class of problems is that described by the seminal long line of cases on the dangers of a vague indictment without clarity. What did Mr. Banks allegedly pay or promise to pay as quid pro quo for the murder? Mr. Banks is not permitted the opportunity to prepare an adequate defense or to address himself to the relevant questions of fact and law. The government theory at trial strays from what was presented to the grand jury. The vagueness permits the government to shift its legal theory as the case progresses, as the government has been doing here, and it creates the risk that a defendant will be deprived of the protection against double jeopardy. In this prosecution, we see these dangers unfolding as outlined below. Hey, listen. This what Durk ain't think about. This what the people out there that's saying, they about that life, they should think about, man. Because this is the game now. Once they get you locked in, they gonna start playing it their way. Once you violate the law and you gotta sit down for something like this, they're going to start playing the game their way. They not playing fair. Not at all. You know, people think that they supposed to play fair. Hell no. They play unfair all the time. Straight up. Yeah, they play unfair all the time. It said, in the last several weeks, the government's theory of guilt with respect to the murder quid pro quo, what is colloquially calls the bounty, has taken a turn. The government for the first time articulates the theory that certain listed music videos and rap songs are the bargain for consideration for the charged murder. Hey, yo, they're using Durk's music, man. They're using the music, man. You know, and, you know, we can say they shouldn't use the music and why they shouldn't use it and it's only music, but it lets you know that they're using it. Now that shit sound good when people making it and they out there popping it. Yeah, it sound real good when people out there making music and they popping it. But just know that they will use it against you no matter what you say. Yeah, you're supposed to have freedom of speech and it's supposed to be art. Yeah. But they playing dirty. In other words, the opportunity to rap a verse or appear in certain music videos is now, for the first time, alleged to be the payment in exchange for the murder. They're using Durk's music in his case. The first two 404B notice contain no allegations that any rap lyrics or videos are considered for murder. The government didn't want to lay their case on the table. You know that. The government didn't want to lay their whole case on the table. This is why they said what they said. Now, they putting the case out there. The trial rate come up. All right. Yeah, we using the lyrics. Come on now. You thought that they wasn't? You thought they wasn't? Okay. Yeah, you thought they wasn't. You tweaking. The government's first 404 notice contains no allegations that any lyrics or videos were payment in exchange for the charge of murder. The notice dated September 15, 2025 lists 4 songs. Its proffered purpose for admitting one of the songs is that it is an admission that Mr. Banks was under pressure to avenge King Von's death. As to the other 3 songs, the government proffered that they are admission by Mr. Banks that he ordered violence and paid bounties. Similarly, the government's second 404B notice does not advance the theory that Mr. Banks paid for this murder with rap song music video features. The notice dated November 17, 2025 added 2 songs by Mr. Banks to its previous list, alleged an admission by Mr. Banks that he pays for bounties and directs violence. Reasons contained in the first notice. And also, for the new purpose of showing Mr. Banks' relationship with the OTF co-conspirators, the second notice also lists 4 new songs and proposed 404B against Mr. Wilson. Again, the government stated purpose in introducing those songs and evidence is that they are admission, not that the rap verses or videos themselves were conferred upon Mr. Wilson's as quid pro quo for murder. Hey, yo. Durk thought that he could just say what he wanted in those songs. Yeah, it looked good to the people. So all the young people out there that was hyped up to Durk's music when he was talking about them homicides and how he'll slide and get this person to slide for Vaughn. the government now wants to use that as evidence. And, you know, the people, right, can say, oh, they shouldn't be able to use the music. The people ain't got no law degree. The people with the law degree is the ones saying, we gonna use the music. You reference this, you charge with this. All right, so we want to show where you said this, and this is what happened. Durk is in trouble. You know, his lawyer trying to get it thrown out, whereas though they can't use it. But when the situation is directly saying you gonna do this, and then they're accusing you of this, I think it's gonna be real hard for them not to use it. If they're saying your music is saying specifically that this is what you do, and you've been accused of this and charged of this, why wouldn't they use it? Straight up. The government fails to identify any evidence that supports the theory that rap lyrics and music videos are quid pro quo for the murder. Now, I gotta say this, right? His lawyer is supposed to do his job, right? He's supposed to fight hard. He's supposed to challenge everything that the government is going at Lil Durk with. This is what he's getting paid for. But at the end of the day, right? If a guilty verdict comes down, the lawyer gets millions of dollars and he goes home at the end of the day. Straight up. At the end of the day, the lawyer goes home. Durk is the one got to sit in jail. And of course, a lawyer is going to fight tooth and nail. The lawyer going to say, no, they shouldn't use this. No, they didn't tell us this. No, they said they was going to do it this way. That's what the lawyer's job is to do. But the prosecutor's job is to do the opposite and say, yeah, this is what we're using and this is why we're using it. So it's like a battle of who's going to be right and who's going to be wrong. What way is the court going to sway? Now, let's just be real. The judge is there to be a referee, right? But the judge and the prosecutor are on the same team. This is why, you know, with the system, it's hard on you. The odds are against you. The prosecutor and the judge are on the same team. So of course they rocking together, right? But the judge is supposed to be the referee. So when the prosecutors bring to the judge and say, look at the rap lyrics, right? The rap lyrics are saying exactly what we're charging them with. It's not like they're saying something different, right? And Durk has specified sliding directly for Vaughn. This shit sound good on music. The songs went up. People ran around bumping them. But the prosecution, they gonna point out specifically what the music is saying and what the charge is, the reasoning and everything. So that's looking bad for him, man. Yeah, that's looking bad for him. At the November 18th hearing, the court directed the government to file those portions of the discovery that encompass its theory as to bounty. So here are you telling me that those hundreds of pages filed at docket entry 293 encompass then what it is that the government would argue as to either bounty on one's hand or the means by which allegedly Mr. Banks directed the crime occur, DKT number 317 at 30. And later, what I'm going to do is tell the government that if the government can rest on what it's already done, which is, as I was told, was document number 293. The government may supplement that between now and Friday. In response, the government informed the court that it rests on docket entry 293. That filing contains no evidence to support the government's current theory that Mr. Banks conferred features in rap songs or music videos to his alleged co-conspirators as a mutual understood payment for the murder. The government was playing chess. The government was playing chess. Straight up. The government was playing chess. Yeah. They didn't come out from the door and say what they was going to do. Now, the lawyer, Drew Finley, knows this, right? But his job is just to defend Durk. All right, I'm going to put this motion in. I'm going to say this. People got to understand, man, they all are attorneys. You know, Drew Finley wants to beat the case for his rep, I'm sure, right? But the government wants to win this case for their rep too. They want rep too. And the person that, you know, is on the chopping block is Durk. All these people that are involved with the case that are on the other sides, the outsides, but they are involved with the case, they go home. They go home now. You got to understand that. They go home. The government discloses a new theory. The government's January 16, 2026 notice is third mark, the first time it articulates the theory that rap lyrics and music videos are the items of pecuniary value exchanged as consideration for the murder. The notice again adds 2 new songs to the list in addition to those listed in the first 2 notices, for a grand total of 12 songs. More importantly, it adds a new theory as to an essential element for murder for hire, that the list 12 songs are admission and visual showing the downstream benefits received by co-conspirators involved in the murder for hire scheme, including defendants and uncharged co-conspirators, participation and prominent placement in the music videos following SR murder. DKT number 350 EXC at 3, the government's January 30th filing on the 4B issues echoes the argument that the songs and videos contained in the third notice prove the downstream benefits rewards to the co-conspirators involved in the murder scheme, including prominent placement in the music videos following SR's murder. DKT number 367 P9. In its January 23rd filing, the government argues that the indictment, coupled with the discovery, provide clear notice to the defendant of the government murder for hire theory. Hey, listen. Let's just be real. The government will say whatever they want. They're not going to tell you their theory, their game plan ahead of time. That's what they just did. They played the game with Durk's lawyer and Durk. They didn't want to tell them the theory ahead of time that they were going to use the 12 songs that reference Durk saying things about murder for hire. Now they're showing that, all right, trial about to come up. This will we using. What you gonna do? So they do things like this to give you limited time to prepare. And this is what's going on now. Because Durk's lawyer, what he gonna say to Durk's rap lyrics? Durk specifically says certain things. It's trouble. It's trouble. Mr. Banks rewarded co-conspirators by, among other things, featuring many of the direct participants in the murder in the music videos and rap lyrics in the months following the murder. On the contrary, the government never alleged before mid-January that these or any music videos or rap lyrics were consideration that Mr. Banks promised or paid in exchange for the murder, or that the expectation of these features were the motivation to commit the murder. The second superseding indictment merely names vague, lucrative music opportunities, which could mean many things, from rap verses to concerts to record deals and beyond. So they're using that too. People wanted music opportunities. In the wake of the second superseding indictment, the government has had every chance to make its theory clear. Instead, it has taken advantage of the indictment vagueness, a carte blanket, to continually disguise and reinvent its case. At the November 18th hearing, defense counsel articulated this danger and foreshadowed the current situation. Late night, we got a discovery production. Now, late night, remember that? We got a discovery production from the government. And I won't get into details because it subjects to protective order. But it was an FBI 302, and it listed about 15 different music videos, and those videos involved or depict some permutation of Mr. Banks and Mr. Wilson's, or Mr. Banks and protected witness number one, some permutation of the three of those people. And so I get this 302, and the first thing I think is, oh, there is obviously these vague allegations in the indictment that as a bounty, Mr. Banks provided lucrative music opportunities and co-conspirators provided those lucrative music opportunities. But we are left to wonder, what lucrative music opportunities is the government alleging were related to bounty? So I'm looking at these music videos and I'm thinking, okay, is the government going to present these to the jury in such a way that the jury could draw an inference that Mr. Banks featured Mr. Wilson, or PW1 in a music video is a payment or a bounty? And you know, one of the problems with the vague indictment is that it gives the prosecutors free hand to fill in the facts and fill in the gaps about which facts it wants to use and satisfy. Whoa. It meets the elements, and it also illustrates the government shifting theory, because we have a statement that there was never any music opportunities that was a bounty. And then maybe kind of there was a fear of a loss of music opportunity that was a bounty. And now, are there new music videos going to be presented to the jury in such a way that they could draw the inference that those were a bounty? And so this is not just theoretical case law. This is something that prevents us from doing our job as the Constitution requires. Man, the government's gonna play dirty. Oh, they playing dirty. You better know it. It's their game. This was an opportunity for the government to clear up any ambiguity about what its bounty allegations actually are. Instead, it chose obfuscation. That's different. The fact of the music videos that some of the defendants or protected witnesses are in together doesn't necessarily just have to be about bounty. It can be about motive. It can be about relationships between co-conspirators. It could be about the formation and organizations of only the family. All of these points, as the government addresses, is its opposition as to 404B evidence and relevant. So music videos and presence within music videos is not just about bounty. Either the government had not yet come up with the theory on November 18th that music videos and rap lyrics were consideration for the murder, or it wanted to keep the defense in the dark. Just what I said about the quid pro quo theory in order to secure a tactical advantage and concealment that would offend the constitutional principles of due process and notice. Exactly what I said. Straight up. Exactly what I said. The government didn't tell the theory because they wanted to surprise the defense, man. It's their game. These are the things that people don't think about when they out there in the street. They did this on purpose. Now Durk's lawyer is trying to fight it, but if things are specifically pointing to what they're charging Durk with, I don't see how they're going to get it excluded. Straight up. The new theory is a government invention and threatens to wrap witness testimony. Hey, listen, they got protected witnesses now, and they're going to get up there and say some shit. Yeah. Oh, they're going to get up there. The government newly articulated theory is its own invention, unsupported by the evidence. The government incorrectly asserts that its discovery, they're not playing. I'm telling you, they're not playing. They're not playing. The government incorrectly asserts that its discovery clearly supports the straightforward theory that Mr. Banks rewarded co-conspirators by, among other things, featuring many of direct participation in the murder in music videos and rap lyrics in the months following the murder. In actuality, the discovery contains nothing to support of that theory. This is why, in response to the court order that the government file any discovery that would encompass its bounty theory and await the need for a bill of particulars, the government filed nothing that touched on the music features as quid pro quo allegations. Indeed, no witness has ever told the government that Mr. Banks offered or awarded features in songs or videos as payment for the murder. No witness has ever told the government the murder was motivated by the promise of music video or rap features, affirming that it is a motive of the murderers that is relevant to whether the murder occurred in return for promise to pay something of pecuniary value. Not one witness, not ever in the place of the actual evidence, the government appeared to have searched the internet for every musical collaboration between Mr. Banks and the alleged co-conspirators that post-dates the charged shooting. It then constructed its own inference that these collaborations are the murder quid pro quo. To reiterate, no witness to date has told the government that Mr. Banks paid for the murder with the music videos and songs featured the government lists in its third 404 notice, or with any music opportunities for the matter, or that the murder was motivated by the promise of expectations or such. It thus appears that the newfound allegations are the invention of the prosecutor's imagination. The danger of going forward is the government's witness will change their stories to meet the requirements of the government's new theory. We have seen it happen already over the course of this investigation. For example, a witness who admits to the murder but denies that he did it for pay changes his tunes in response to repetitive and suggestive government questioning about payment. If it happens here, and if at trial any of the government current cooperators testify that he was motivated to participate in this murder by understanding that he would be featured in music videos or rap songs, then it will be downstream repercussions of this vague indictment. It will be an unconstitutional miscarriage of justice. Conclusion: Mr. Banks continues to seek dismissal of this dangerously vague indictment. Short of that, however, he requests that the court require the government to file a bill of particulars that is tied to the theory it presents to the grand jury. When the United States government seeks to charge somebody with the crime, it should be willing and able to inform him of what he has done that alleges to have violated the law. The government should not be permitted to change its story along the vicissitudes of the case as it has done here. Do y'all hear this? Do y'all hear this? So now the government has a different theory of how they're going at it. They didn't present what they was going to do from the door to keep them off balance. Now the witnesses, right? So his lawyer just said right there that the witnesses have admitted that they did certain things and that they were involved with the crime. And from what I'm seeing, allegedly, the witnesses have admitted that Durk paid for the hit, but they didn't say that Durk said that he was going to give them music opportunities for the hit. So the lawyer is doing this. He's trying to get the music excluded so that they can't reference the music to what the witnesses is saying about the hit, so that it makes it whereas though Durk can still have a fight. So now if they got these witnesses saying that Durk paid them to do this, but they're not saying that the music was a part of it, and they got the witnesses cooperating and testify, and then they use the music to show, all right, Durk is saying this, these people were in the music, and this was associated with it, but the people are not referencing the music. It makes it whereas though Durk doesn't have a fighting chance, because the music is saying one thing, right? And it's directly pointing to what the case is. And then you got the co-conspirators that's testifying saying the same thing that the music is saying. So it makes it stronger. And this right here is a problem for Durk's case. This is a problem for the case. And from what I see, the lawyer is trying to fight it to get it thrown out, whereas though they can't use the music and just use the witnesses. So it'd be like his lawyer can fight the witnesses and saying, well, you got caught for what you did and you're just trying to blame my client, right? So he can have like a defense with that. You got caught. But now what the prosecutors are trying to do is whereas though they got the witnesses saying this, well, we're going to use the music to corroborate it. Even though the music is not what the people are saying they did it for, but we're going to use the music to corroborate what the witnesses is saying. And it's like bingo, signed and sealed. The situation is looking bad for Durk. Straight up. Now his lawyer is trying to fight. He's getting paid millions of dollars to fight. So he's definitely trying to fight. You know, he's trying to get the music whereas though it can't be used. But you know, the government is not going to reveal all their evidence from the door. They wouldn't do that. That would give you too much time to prepare. You would be able to try to get them at their game. So of course they're going to play the game. They do certain things a certain way. They'll give you the evidence right before the trial. So you don't have enough time to really review it. And when you're looking at evidence, you need to review it a whole bunch of times to really catch it. You can't look at evidence in 1 week and be able to really know your angle to go at it. Then you got to have time to file motions to get certain things thrown out. You might catch key words in the evidence, whereas though you don't want this in because the evidence is saying this and this, and you know, is really, you know, violating the constitutional rights. So Durk's lawyer is trying to fight, but from what we see right here, it's looking bad. You know, yeah, the people are telling. Their witnesses are identifying that Durk definitely was a part of it. Straight up. Yeah. But the lawyer trying to get the music stuff thrown out because they're not referencing to the music. And I don't think it's going to go, you know. But what it does, right, to Durk, see, and this is the mind trick of the people, right? So what it does to Durk is Durk looks at it like his lawyer fought, right? This is what the mind trick looked like. And it looks like that to the world. So now when somebody get in a situation, they're going to look at, all right, let me get Drew Finley. Let me get him. Because it looks like, all right, man, Drew Finley went hard. He definitely put the motions in. He made key points. But the key points that he's making, they're not strong enough to override what the prosecution is saying. You got witnesses testifying. And they implicating Durk. You got 9 witnesses testifying. And I'm going to tell you straight like this. For them to have protected witnesses, they have valid information directly pointing at Durk.